The next matter is Shopping Mall NY LLC. We have the confirmation hearing on the third amendment, Chapter 11 Plan of Reorganization. We have the motion to estimate claim of Desiree Yagan for voting purposes. We have the motion for evidentiary hearing and motion for Rule 2004 examination, motion for adversary proceeding filed by Desiree Yagan. We have the motion to allow claim temporarily for voting purposes by Desiree Yagan. Ms. Weinrich.
Good morning, Your Honor. Sarah Weinrich here on behalf of the debtor, and my colleague Harry Greenfield is here as well.
All right, I see Mr. Greenfield. Who else is here on this case? Let me see. Ms. Yagan.
Judge, I apologize for the interruption. We were having some interference on Ms. Yagan's line, so I did mute her, but if she can just hit *6, she'll be able to unmute herself.
Very good. Ms. Yagan, can you hear me?
Yes, Your Honor, I can hear you.
All right. Anybody else want to enter their appearance? Right now we have Ms. Weinrich and we have Mr. Greenfield and yourself. All right. Let's start with, Ms. Weinrich, your motion for the plan, I think, is a little bit contingent on Ms. Yagan's claim. So maybe we should address her claim and her issues first and then go back to your confirmation, unless you have some strong belief.
No, I would agree with you, Your Honor. I think that makes the most sense. Like you said, depending on the outcome of the motions related to her claim, that will guide us for the plan confirmation.
All right. Thank you very much. I have Ms. Yagan. We're going to deal with your motions first. I have spent a lot of time reviewing all the pleadings that have been filed, the proof of claim, and the prior hearings on this case. So I would like Ms. Yagan to indicate to you that that's why I've issued the orders I issued, so that we would make things clear for you.
First of all, Your Honor, it's important that I notify the court. It's very important that I obtain legal advice, and it's been very difficult here in Onondaga County due to the fact of it has to do with his name is Onondaga County District Attorney William Fitzpatrick. The issue is that he has named me as a defendant in a sign violation. He cannot be a victim in a sign violation, but the reason why I bring that up is I have the district attorney claiming to be a victim in a sign violation. That's a posting ordinance violation. And why it's relevant here, Your Honor, is to obtain an attorney. The attorneys are very, very adverse to representing anyone who has any issues involving the district attorney of Onondaga County, William Fitzpatrick. It's not that I don't want assistance. Of course, bankruptcy, Your Honor, I understand it's very complicated, obviously. And I had no knowledge whatsoever about bankruptcy until after the confirmation hearing, which was on December 14th. And I only discovered about Shoppingtown Mall. Had filed Chapter 11 that affected me on December 10th. Well, actually, December 10th, I didn't know it affected me, but I still contacted the court to file an objection just to be extra safe. Now, addressing the issue, and I apologize, I'm more than a little stressed, because this morning I thought I was going to be calling on a landline. I purchased the phone, and then I was advised by I rent a room in the house, and the individual, his name's Ron. It's a 110-year-old or 130-year-old house. The reason why I tell you that is because apparently there's only one connection. Anyway, and you have to have a calling card. I didn't know you have to have a calling card to use a landline. Well, apparently he does that for long distance. So I've been really, I've been dealing with that, and then I couldn't access it. So I'm using my cell phone, and I just want the court to know. I understand the court hears me perfectly, but I'm getting a lot of feedback, and I had no choice because I couldn't even use my landline because I need a calling card, which he didn't tell me until I was doing a test of it 2 hours before the hearing, and that's when I found out you can't call out on the landline here. You have to have a calling card. So it's just more distraction for me, and I apologize about that. Now, I do want to address this issue that's in front of me, which I see in the order by Your Honor, that the debtor did not file he didn't file an objection to the claim, okay? What he did is he simply, and I object to the fact that he didn't file a formal objection to my claim. What I assert to the court, Your Honor, is that they just don't want to cite Desiree Yagan in anything that in the record whatsoever. That brings me to the issue, and I know I'm kind of moving back and forth, but it's very important that this be addressed. The first time, Your Honor, I found the notice of bankruptcy case filing. Oh, I know what it looks like. Where did I find it, Your Honor? They never sent this, and that goes to the issue, Your Honor, of the necessity of having a Rule 2004 examination, because I have to prove I have to prove a negative. It's considered regularity, whatever the term is, mailing regularity. I do want to stress to the court, when I misspoke on December 14th, I was so shocked to find out about this bankruptcy case, and then became very increasingly concerned over the weekend. Maybe this does affect me. Your Honor, it is well known that this is very complex. No person who's not an attorney would know that would understand that could affect you. That's why the notice that is called the Notice of Bankruptcy Case Filing has to be sent to, in a Chapter 11 case, to every known creditor. And the issue is here, Your Honor, they knew, number one, I didn't receive it. That is where I have to present to the court to file evidence in support. The issue goes to which I stated very clear, vehicular assault. The woman stated she didn't hit me. That's what it says in police report. She didn't hit me, and that I fell to the ground. It also states in the report, Your Honor, and this goes to the area of destroying evidence. I'm asserting to the court, which I can prove, that what the evidence would be and is of the vehicular assault is the surveillance video of the parking lot, Your Honor. I can only prove this in a Rule 2004 examination, Your Honor, because I need them to produce the document. That a videotape of the surveillance of the parking lot is cited in the police accident report. The officer states that he had the security for the Shoppingtown Mall reviewed the surveillance tape of the parking lot. There was nothing on it. Regardless of whether, but when I spoke to it, and again, this has to be shown by evidence, not just statements by me or the attorneys. But I will tell you, Your Honor, that the surveillance tape, it would require, they had to file an incident report or some sort of report with the insurance company. They have to preserve the videotape. I'm asserting to the court, there's never been an incident report filed. There is no surveillance tape. Or if there is, in the alternative, there is, no one would ever take my statement regarding it. They said there is no incident report. They even denied the security and the management, denied any knowledge of the incident. My legs were broken in the parking lot, Your Honor, and the DeWitt police refused to take my statement. When the police officer came, the woman runs her car into me from the parking space, accelerates from a standing position in the parking space, and runs her car into me, Your Honor. I'm 15 feet from her. Then she steps out of the car. I go down, Your Honor, and I shout, "Why'd you do that? Why'd you do that?" I was in shock. And then, I didn't know. I just knew it was excruciating. Well, when the officer arrived, I told him, I said, "She hit me deliberately. Preserve the videotape and send your sergeant to the ER. Take my statement." So the point is this, Your Honor, is that the video in the police report, which I didn't see for 4 weeks until it was faxed to me by the police clerk, James M., faxed it to me at Van Dyne Rehab Center, Your Honor, because I made repeated calls to the police department. You have to send someone to take my statement. Send the sergeant or the officer to take my statement. No one has taken my statement. I said, it's a vehicular assault. I said, I want the woman arrested. They wouldn't even take my statement. Now let's look at Shoppingtown Mall, Your Honor. When I called them, I wanted to give them my statement. I said, you have to preserve the video because I'm all about evidence, Your Honor. I'm very familiar with surveillance cameras.
Now,
okay, Your Honor.
Said that to you. All right. First of all, let's start with these lawyers that potentially you're hiring. Are they bankruptcy lawyers? Are they going to handle your bankruptcy?
Yes.
All right.
Yes,
and
Your Honor.
When would they be available? Because I want to schedule everything for the latest July. So when are they available?
I would need to
be talking to you and committing.
Exactly, Your Honor. I will be able to give a firm answer, but I will need a couple of days to give you a firm answer on that because I have to.
No, I don't want an answer from you. I want lawyers that enter their appearance. If they are going to enter you can't be communicating with me or anything like that. They enter their appearance into the docket.
I haven't hired anyone, Your Honor, and at this point, I am just pro se, Your Honor. There is no attorney representing me. I want to have advice, but right now, I'm pro se, Your Honor.
Right, pretty few months. But we need to move this case along. We have had a lot of litigation and issues in this case that have been resolved. You are the only thing that's holding this case up right now. And that's detrimental. Wait a minute. This is detrimental to this case. It's detrimental to the lawyers that are running up all kinds of fees because of the items you're filing. And if you have a valid claim at some point or allowed to file a claim, then that you will be part of the creditors. But at this point, you are not there. So let's go through each of your items. One is your motion for evidentiary hearing, motion for Rule 2004 examination, motion for adversary proceeding. That document. That, and with respect to the motion to estimate claim of Desiree Yagan by voting purposes, I would like to continue that to the same date that I'm going to put. I think after, I have to think about it, Ms. Weinreich. I'd like you to address it, but I was thinking of scheduling a hearing where Ms. Yager can demonstrate her excusable neglect. If I find that there was excusable neglect, then we will get to the claim evaluation and whether it was, it's documented correctly and all that. So now we go back to the issue of the plan and the confirmation of the plan in Ms. Yeager's claim. The only issue I see, Ms. Weinreich, for you is that, for the debtor really, is that everybody is on for the plan. The plan can be confirmed. There are no issues. It's only Ms. Yagan's objection and that only issue. So if I resolve the issue to her claim, the plan could be automatically confirmed. Is that not correct?
I believe so, Your Honor. Yes.
I think I would like you to put on the record those items because potentially we could at some point confirm that plan with Ms. Yeager's claim or without her claim. I don't know. It depends on how we find her claim, correct?
Yes.
Which is the only issue.
Yes, that is correct. And if it's okay with you, Your Honor, then while I go through all of the other items in the plan, I would address both the threshold number of what Ms. Yagan's claim would have to be for the plan not to be confirmed with her to reject the plan.
All right. Yes.
Okay.
By the way, do you want to do that or anybody else involved with you? I don't want to push you to do it if you're not the one that's needs to do. You don't need to do the presentation.
It is on me today. So I will go through that. So as Your Honor is aware, back in November, we had a global mediation. There were 4 taxing bodies involved at that point. We were able to resolve all of the taxing bodies' claims. As a part of that settlement and the agreement, the debtor conveyed most of the mall property to the county of Onondaga, who in exchange purchased the property for cash payment of $3.5 million at the time of closing. There's also a $1 million option that a future purchaser can exercise to purchase the remainder of the property that the debtor owns. And then as the property will be sold by the County of Onondaga pursuant to an RFP sale, the request for formal proposal, there is also additional funds that will come into the estate depending on how much the property sells for at that sale. Would you like me to go through those numbers again? They are in the plan, but I'm happy to go through them.
No, that's fine. Just build the record on the voting and how the plan is going to be implemented.
Okay, understood. So looking at section 1129, which governs the confirmation of the plan, we believe that the plan satisfies all of the sections. Section A of 1129 requires that the plan complies with, this is 1129A1, that the plan complies with the applicable provisions of this title. We believe that the plan is in compliance with the Bankruptcy Code. I'll go through a couple of the sections. So section 1122, the plan is in compliance with that because the classification under the plan provides for creditors assigned to a particular class. They are substantially similar creditors and claims. So classes 1 through 4 we have classified separately. We believe those classifications are fairly moot right now because those were the taxing bodies and their claims have since been satisfied. Class 5 is the DIP lender, Beacon Commercial Limited. Class 6 was the deficiency claim of the one taxing body, Onondaga County Department of Water Environment Protection, but they have since been satisfied. Class 7 is the general unsecured creditors class. And then Class 8 is the equity owners. So that is Beacon Commercial Limited and AT Realty. So then under 1129A2, requires that the proponent of the plan complies with the applicable provisions of this title. We believe that the debtor is in compliance with the Bankruptcy Code, and in determining whether the plan proponent has complied with the section, courts focus on whether the proponent has adhered to the disclosure and solicitation requirements of section 1125 of the Bankruptcy Code. Plans that do comply with section 1120, the plan does comply with section 1125 of the Bankruptcy Code. On March 31st, at docket number 561, the court entered an order approving the disclosure statement. The debtor has complied with all applicable disclosures and solicitation set forth in the Bankruptcy Code, bankruptcy rules, local rules, and the disclosure statement order governing the notice, disclosure, and solicitation in connection with the plan and the disclosure statement. The disclosure statement, the plan, the ballots, and the notice of the confirmation hearing, all other related documents were distributed to the parties in accordance with the disclosure statement order. On April 5th, 2021, at docket number 565, the debtor filed a certificate of service indicating that all services were executed pursuant to the disclosure statement order. On May 6th, 2021, at document number 593, and then amended at document number 597, the debtor filed the summary of the ballots. And on May 3rd, at docket number 585, the debtor filed the certificate of no objections to the confirmation of the plan. We do recognize that Your Honor is considering Ms. Yagan's claims as an objection to the plan right now. So I guess that's not entirely true, but we didn't know about that.
No, I am not treating her filing of these motions as objections to this plan. She is dealing with her claim. And as a matter of fact, there were no responses filed. People were supposed to, the entities were supposed to respond by 5/3. There has been no responses to your plan. So I think the plan is feasible. I think the record is clear from the background. I want to resolve her claim and see where she stands, but I don't see that that's going to change what you have put on the record and the prior history and stipulations in this case and settlements as to this plan. But I am going to continue confirmation to see what we do with her claim because I want to see what happens with that. I don't want to be premature in confirming the plan.
Understood, Your Honor.
I don't have what I would consider valid objections to the plan itself. All right? All right. I think that's fine.
I guess, Your Honor, the only thing I wanted to address as well is just the tabulation of the ballots then and how it might change. So let me check where I have the summary of ballots. Because, so Ms. Yagan filed a proof of claim in the amount of $11 million. Certainly, if her claim is allowed in the amount of $11 million, Class 7 will have rejected the plan. We do not believe that's the case. And as I indicated in the ballot summary, unless Your Honor finds that Ms. Yagan holds a claim of $698,308.28 or more, that Class 7 will still have accepted the plan. And so in that instance, while she will have a claim at that point, the plan still could be confirmed over her objection or over her rejection of the plan.
Yeah, we don't have an objection right now. We have a rejection. Yes, I understand. All right. Let me go through. So the plan confirmation and your motion to estimate the claim of Desiree Yagan is going to be scheduled. You'll see a text order. We'll do a written order so that Ms. Yagan can get a copy of it. So that will be put at a certain date. Now, with respect to the hearing on the motion by Ms. Yagan to allow an untimely claim, I'm going to give Ms. Yagan an opportunity to establish excusable neglect, and the court will set forth relevant items she must address at that scheduled hearing. Ms. Yagan will be permitted to present her arguments, her own testimony, and any other evidence she wishes to present to support her request to allow an untimely claim. That's where we're going. Want to deal with that first. A deadline will be provided to both Ms. Yagan and the debtor to exchange any exhibits that will be presented in court and to file said exhibits on the docket. The exhibits shall be organized in orderly fashion, which will be addressed in the scheduling order, so that the parties can easily reference the exhibits. How much time do the parties need to prepare for this hearing? Ms. Yagan, I'm going to let you tell me first. I intend to hold the hearing no later than July. So how much time do you need to prepare for that hearing?
Definitely as much time as I can be afforded by the court. So that's what I'm asking for.
Well, you can't have months and months and months, because this case we have to distribute to the other creditors. At this point, we want to confirm the plan and distribute monies.
To answer your question, Your Honor, let's see, this is May 12th, and a month from today.
So you're saying you could be ready in June?
The end of June.
Okay. How do you intend to participate at the hearing? Do you have a capability to appear via video conference, using Zoom, or do you want to continue appearing by phone, or do you prefer to come to Pittsburgh to appear in the courtroom?
Your Honor, I assure you that I'm going. I will have a computer that will allow me to proceed on Zoom, unless at that point that there can be actual physical appearances, because I certainly would be interested in that as the best form of the hearing for me in person. But if not, then the Zoom would be the next best method, and that will require me to obtain a new computer or something. But I will do what needs to be done, because this is very hard for me to. I mean, it's all new to me and everything. But that I will definitely be prepared, and it will have, unless it's in person, where it's allowed to have actual hearings, and I suspect that we're getting there with COVID. But if the alternative by Zoom appearance.
All right. So you would be available. I guess your answer is by Zoom or in person. I don't know that we're going to be able to have in-person hearings in July, and that's what I'm thinking of this case. or end of June. As you indicated, you'd be ready in 30 days, so end of June, beginning of July. I don't think we'll be in the courtroom at that point operating without Zoom. So I guess we'll be in Zoom. Is that right?
Yeah, I just want to voice my, it does Zoom because the attorneys and mostly even younger, high school, I understand they're all do Zoom, Facebook, Twitter, TikTok, all that. I mean, I've never done any of that, so this is, it certainly puts me in a disadvantage, Your Honor, because of my circumstances. I am pro se, and because again, I've not had any experience. I'm a very rare individual. I know that. Most have had some experience. I've seen even kindergartens on Zoom because the class is at home. And the only reason why I can't do it at this point is because my computer was hacked and it won't connect. I've got all sorts of issues, so I need to.
Let me just tell you, there's no more time. So you have to resolve your issue from your side.
I am going to. Yes, Your Honor.
Resolve it whatever way you have to. We have extended this many times because of your issues with your phone, your filing, problems with getting things in. No more. We schedule something, you present your evidence, and I'm going to rule as soon as I can. So we'll issue a scheduling order. I do want to point out that I found a case that everybody should look at, and it's called In Re Draw Another Circle, LLC. It's at 595 BR 174. It's the Bankruptcy District Court of Delaware. It's a 2018 case. I would suggest, Ms. Yager, you take a good look at that case. It's called Draw Another Circle, LLC.
595. Okay. Yes, Your Honor.
595
Yes.
B period R period, which is the bankruptcy reporter.
Yes,
174. I know they took things up because you've cited things to me. Bankruptcy, District of Delaware. That's in our circuit. 2018.
Okay, I will. Definitely, Your Honor.
All right. We'll issue the orders. I am really thinking that we'll schedule this. I haven't decided. At first, I was thinking of putting everything together, but now I'm thinking you're going to see an order where we'll have the hearing on the excusable neglect, and then I'll have another date set for the estimated claim and plan confirmation. But I think the record has been built to potentially confirm this plan. So we're in a good path. Any questions from anybody? Or any comments anybody wants to make? All right. We'll close the hearing.